In the instant case, it is seen that the allegation of cruelty made by the appellant husband, apart from being disputed, there is a different version given by the respondent wife. Evidence on record may not be held to be conclusive to grant a decree of divorce on the aforesaid ground of cruelty. A marriage under the Act of 1955 is ultimately a sacrament, which should be endeavored to be preserved, though there may be some certain friction between the parties. Of course, when a case of cruelty or any other grounds prescribed in the Act is clearly made out, matter may be different. As laid down by the Honorable Supreme Court, allegations of cruelty made by a husband and such allegation made by the wife are to be examined on different yardsticks depending on the facts and circumstances of the case. In the considered opinion of this court, conclusion arrived at by the Learned Family Court in dismissing the suit is based on materials on record which consist of the pleadings and evidence. Appeal is accordingly dismissed.
Public.
Certain matter may be passed over for time being lordship. My senior client officer election.
Time will not be possible. My sister
Lordship,
colleague has
just
to
for
leave.
few minutes, lordship. Will
Not be possible. We'll have it in the next week.
lordship matter is that urgent.
Arjun, so you have to be there. Are we saying that we are not going to take up? Argue the matter?
Actually, lordship, he is on court number 1.
Understood, but
Lordship, only 20 minutes is coming, lordship. After 20, lordship.
my sister has to leave.
Okay.
She has to reach the airport. It's out of turn. We have said today. On Monday or whenever?
Tuesday, lordship.
Tuesday.
Yes.
Yes. A prayer for adjournment has been made on behalf of Sri K. Chaudhary, then senior counsel for the appellant. Who is there on the other side?
I'm there.
Okay.
In item number 2, I'm there.
Three
One.
BD Das, London senior counsel, as well as APSC. Sri P. Dotto, Learned standing counsel APSC are present. Para, as requested, list on
Content.
first of. Okay.
My lord,
Yes.
may I please your lordship? I beg to mention criminal appeal, my lord, similar criminal
Mentioning
appeal.
is over, madam.
My lord,
Mentioning is over. This was item number 1.
my lord,
Okay,
I
what
call
is your prayer?
my lord to come up on list for listing, my lord, to come up on 1st October, my lord. Similar appeal, my lord.
Appeal of which year?
Here,
Which
for
year?
admission, my lord.
New matter.
New matter, my lord. Must apply.
Make legal lordship. My lord, here the accused petitioners were there to separately file another appeal. Probably in that appeal, my lord, note has come. LCR must have been placed with the other appeal. So, my lord, I want to do it independently, my lord. Can it be done this way, my lord? Any day before the vacation, my lord, because since 5 years he has been in jail. So
You have the paper book.
paper book is not yet prepared.
Yeah.
Not prepared.
Paper book would be required. LCR has been called for in some other cases.
No, my lord, there are 3 accused petitioners. One is me and the other 2 in some other appeal. In that appeal, LCR must have been dealt with.
That is it.
Yes.
LCR has been called in the other case.
Oh, yes, my lord.
We'll
Because
take this case along with that. We'll hear
Well,
you independently.
I actually want to do it independently
We'll
because,
hear you separately. What is
Yes.
the problem?
my lord, because I am linguisting for last 5 years. And
Without the paper book, will it be possible? It will not be possible.
for suspension of the sentence, my lord, 389.
Under NDPS,
Yes, my lord, there are
NDPS.
grounds, my lord,
grounds
Five-
on merits.
on merits.
On merits, we'll hear the appeal.
My lord, my lord, my lord may direct this way, my lord. I pray, my lord, that immediately after vacation, let the paper book be prepared, my lord.
How, paper book will be prepared expeditiously, but cannot be out of the turn.
Then from the records, my lord, from the LCR. I just, my lord, want
You
to,
cannot make an exception in an NDPS case.
my
Can you
lord,
make an exception in an NDPS case?
I understand, my lord, but
No,
my,
no, we'll take it to the other cases. Your convenience is not the sole thing. Convenience of all the others, convenience of the office. If one paper book is prepared in the other appeals, it will cover your case.
my lord, I am not even sure, but the office note reflects that it has been tagged with the other appeal. Application, no? Fifth. My lord, because my application is up 2023, my
It
lord.
appears from the office note dated 7/9/2024 that the LCR has been called, LCR connected with this case have been called in criminal appeal 3582023, which appears to be an appeal against the same judgment. Full stop. Also heard, Mr. Borofu?
Thank you. Respondent number two, TRM.
We are, and madam, you for? You, state, also heard Ms. So-and-so and Ms. Anthony Boro for BRI, para. List, this case along with criminal appeal 3582023. And after receipt of the records, comma, the paper book may be prepared expeditiously. Matter may be listed thereafter.
My lord,
We'll hear your case different, separately, don't worry.
my lord, I only depend on one witness. That will be would be sufficient from the LCR.
That is your version. We do not know what will open after opening the file, what will divulge.
If your
Well,
lordship
let
allow
paper-
me 1 minute, I can show, my lord. There is a,
On merits, we are not going on an NDPS case. And if you want to argue, if there is an observation made by us, it will be really difficult.
no, my lord, I don't need that. My lord,
Argue on the main case
my lord, in the month of November or
as soon as the LCR is, the paper book is prepared. We have said, ask the paper book to be prepared expeditiously and thereafter to be listed. Okay. Who are the counsel in the other case?
I'm not aware of.
Okay.
Deeply of that.
Okay. For Mr. Purkasta,
Yeah, please, Lordship. Lordship, if you do the construction of the road, like it's a bit, he'll be arriving, and it may be taken up some time. Lordship, please.
no form. No form attached to the with the step. In this
67 days delay.
in this IA, notice was issued on 15/12/2023. Full stop. Office note dated 25/9/2024. However, reflects that while taking steps, the necessary form has not been attached. Full stop. Learned Counsel is granted a week's time to take proper steps. Okay. There's some defect in the steps. You take steps, okay? You see the office note.
May I please, your Lordship, I'm appearing for the appellant. As per Lavazima order dated 23/9/24, service has been completed on the respondent.
Which order?
23/9/24 office note, if your Lordship goes to the office.
LCR has come.
Not as of now.
Office note. No, order of the, order dated 23/9/2024 of the learned Lazima Court reflects that service upon the sole respondent is complete. List for admission. After, immediately after the Puja vacation.
But date,
The respondent may enter appearance in the meantime, if so advised.
okay.
Item 6.
May I please, Lordship, last question, Lordship,
My
Wait.
learned friend A Begum had taken time to file affidavit, the objection.
Okay,
Sir,
filed or not?
she's not here
Okay,
today.
good.
Lordship will give us 2-3 days time.
Okay.
I'll tell her to
Okay.
file as soon as
Okay, okay.
possible.
Due time was granted to the state to
Got it.
file objection, comma, Miss A. H. Jahan, learned additional PP. Assam, prays for some more time to file the same para. List on, we fix a date.
Okay.
On 23rd. Council
Okay,
23rd October,
Before vacation, Lordship.
last week will not be possible. Have it on 23rd, immediately on the 23rd, prior to which objection may be filed.
It next
Give
week
them.
we'll file it, she said.
Also announcement of judgment. Item 47 to 51. of appeals.
In view of the facts and circumstances of the case and the discussions made above, this court is of the opinion that the process adopted for allotting the works to the respondent number 5 is not in accordance with law, and accordingly the work orders are interfered with. It is however made clear that since there was certain progress pursuant to the aforesaid work orders, balance of the works are to be done through the eligible bidders who would be qualified for the same pursuant to tender process. So far as 998 of 2024 is concerned, since no progress could be made, the work is to be allotted to the eligible bidder. Period petitions accordingly stands allowed in the manner indicated above. Interim order stands merged.
Immediately available.
May with regard to Act 37 contempt order that may pray after vacation, otherwise inspection also not exist. My friend,
Yeah, appearing. Okay, on a joint prayer made on behalf of the parties, matter is adjourned to be listed after the vacation, Puja vacation, 37th. Okay.
hello.
Wait, please, Mr. Lordship, my lord. My lord, I beg to mention item number 46,
Yes,
with the concern of the other side matter.
yes.
The senior counsel, they has some personal difficulty,
Partner matter.
my lord.
What is partner? Why is this partner? What is the matter about?
Matter about, my lord, they have challenged the tribunal order, my lord. Under IT Act, my lord, section 33, application filed before the
33C2.
My-
Industrial Disputes Act.
my lord,
Okay. You're taking time on behalf of the respondent.
my lord.
Okay.
Senior counsel, Mr. Jain,
Okay, you've taken the consent of the other side.
my lord.
Will not be treated as partner. We do not know when it was made partner. This is a bench 4 matter. We have been taking debate and bench 2. A prayer for adjournment has been made on behalf of Sri G. N. Sahewala, learned senior counsel for the respondent number 2. Full stop. Matter being of the year 2015, comma. This court has reluctantly granted the adjournment by directing listing of this matter immediately after the Puja vacation, full stop. The matter is not to be treated as part heard. Yes.
May I please your lordship? Lordship, with due respect with regard to item number 5, my lord.
Hmm.
My lord, I'm praying for an adjournment for PJ matter, item number 5.
Okay. 20 matter, why are you
My
seeking?
lord, my family was on bereavement. I have resumed duties from
Okay,
yesterday.
okay. Oh,
I could not prepare.
okay, it doesn't matter. Okay. On the prayer of Miss H.G. Borua, learned counsel for the petitioner, matter is adjourned to be listed immediately after the puja vacation. Yes, higher education.
My lord. I will inform, my lord. I will inform.
Who's their higher education normally? Okay.
My lord, there are two interim orders, my lord. Interim
Item number 5.
5, my lord.
The interim order passed earlier to continue. Will, in that case, will they fix a date?
My lord, can wait.
Uh,
There is other-
interim order passed earlier to continue till the next date. Full stop. List on 23rd.
My lord. Obligement.
Lordship,
23rd.
with the consent of the other side, I
Yes.
beg to mention item number 1 and 3. Matter may be passed over for the day, as my senior is not keeping it.
Okay. On a prayer made on behalf of the petitioner. When next week, is it possible?
Yes.
Matters, matter is adjourned to be listed in the next week. Separate orders, 1 or 3. Yes.
My lord, I beg to mention item number 24.
Yes.
Item number 24. my
Yes. What is your prayer?
lord. I want to, I beg to mention item number 24. Matter may be listed after puja vacation.
24. Contempt matter. Okay. You're for whom?
For the petitioner.
Taking the consent of the other side.
No, my lord, I will inform them.
That will not do, madam.
Actually, we have filed a impleadment petition
You have
yesterday.
to take, we do not know. Before you seek adjournment, you have to inform the other side. We do not grant adjournment without informing. You be here when the matter will reach, we'll adjourn. But don't make a mention without taking the consent. Okay. Next.
Item 2.
Right, Mr. Lordship. Lordship, this is second round litigation. In fact, this is third round. Okay. Earlier, the petitioner approached honorable court challenging the selection of the private respondent number 6, Lordship. Your Lordship will find the order at page 15, Lordship. Page 96, annex of 15, Lordship.
Now, what is your grievance?
Grievance is that, Lordship, this honorable court has directed the DAC to pass a reasoned order.
Yes.
But later on, advertisement was made on 6/7/2024. Order for press advertisement was directed to the concerned police authority, but advertisement was not made. But right, Impin order, Lordship, page 25, the respondent number 6, he was appointed as principal. My grievance is that, Lordship, as per UGC required eligibility criteria, this respondent number 6, so he does not fulfill the required eligibility criteria, Lordship.
Mr. Fukan for GU, what university?
I'm for the Gothenburg similar respondent number
And
5.
madam for UGC.
Your page 94 is the recommendation of the selection committee headed by the Vice Chancellor of Gothenburg.
Yes. 94.
94.
Yes.
Annex 13. The selection committee interviews 3 candidates
Yes.
who were turned up for the interview out of 4 for the post of principal Manchester College. Committee interviewed the candidates, examined the documents and testimonials to verify the.
Did you participate in this process?
Lordship?
Did you participate in this process?
Lordship.
You were one of the participants.
Lordship.
Okay. Heard. Ayasan,
Lordship.
Learned counsel for the petitioner, who is aggrieved by the appointment of the respondent number 6 as the principal of the Mankachar College. Full stop. The petitioner had earlier approached this court on 2 occasions, and there was a direction to the Director of Higher Education to pass the rescind order. Full stop. It is the case of the petitioner that in the selection held pursuant to the advertisement dated pursuant to the advertisement, comma, the respondent number 6 who does not fulfill the eligibility criteria as per the UGC has been selected. Full stop. Para. Let notice be issued. Returnable on 25th of October 2024. Higher education. Higher education. Mr. Sharma. Mr. Gogoi, higher education. Sri K. Gogoi, Learned Training Council, Higher Education Department, accepts notice on behalf of respondent numbers 1 and 2. Miss Madam K. Borpuzari, on behalf of Sri H. Chamuha, Learned Council accepts for respondent 3 UGC. Rest, I think, it'll go by extra copies, huh? Steps for service. You are not there, Mr. You are not a party.
Miller, respondent 5. The selection committee headed by the vice principal. He's the chairman of the selection committee.
Okay. Selection committee. Okay, you'll take notice. Okay. Sri PJ Fukan for 5, huh? Extra copies. Steps for service of notice upon the respondents 4 and 6 were registered posted AD. Steps within 2 working days.
Public.
Item 4.
Lordship, a similar petition came up on 20th. Lordship, I'm praying for it to be tagged with that.
It is coming when? 20?
No, it came on 20th. Lordship,
When is the next date?
it's listed after 4 weeks.
Notice issued.
Yes. And there's notice on stay, interim order.
No interim.
No, notice.
Yes, only notice.
Okay.
29.
You're not praying for interim.
Heard Ms. G. Goswami, Learned Council for the petitioners. This to it. Follow to. Huh? Follow to it. We have this.
Yes. No.
Who has approached this court for regularization of their services. Full stop. It is the case of the petitioners that they were contractual teachers who were initially inducted in the service pursuant to an advertisement dated 10/6/2010. Full stop. Para, the Learned Council has also submitted that there is a similar petition being WPC 4795 of 2024 in which notice has been issued. Para, let notice be issued. Returnable by 4 weeks. Yes, we will be accepting notice. Secondary,
Yes, my lord. I am.
Priyu Sharma, sending on secondary for 1,
Respondent number 1,
2,
2, 3,
3,
1, 2, and 3, my lord.
4, Finance Department,
Fine.
Finance. Anyone, Finance Department? Hey, Chalia, is it there? Chalia is there in the court or not? Or Mr. Borpuzari, Mr. Nayak, or is there? Hey, Chalia, huh? Finance. And Rashtriya Madhyamik Shiksha Abhijan, RMSA, any standing council?
Yeah.
P. Nayak. Name sure or not?
This name has not been.
Access notice, huh? Extra copies. The interim prayer would be considered on the returnable date. List along with WPC 4795 of 2024. Okay.
Apply.
Yes.
52.
इसको बंद कर दिया बहुत ठंडा था
The opposite party has filed opposition.
Objection.
Yes. Be taken on the last week of October. For
Okay. Item number. The objection to this IA has been filed para as agreed to by the learned counsel for the parties. Please for consideration in the
5th of November.
in the first week of November.
Yes.
Para interim order passed earlier to continue till the next date of listing.
Apply.
Item 6.
Yes, Mr. Ali.
May please lot. This is not pension matter, my lord, and you lost is recorded on the last order, my lord. They have to bring the details.
Yes. There was on the last occasion we had noted that there was some communication gap. Have you rectified it?
Right now, I have not written instruction here, my lord. And
Who was appearing on the last occasion? Dewey, B. Dewey.
PWD was there for the
Pension.
government.
Pension, yes, government. Who's for the government? Yes, government council. After a while.
Item 7.
Mr. Vora?
My lord, I am getting only provisional pension, my lord, since
Here.
2018, my lord.
Last occasion.
Court has also asked why compensation should not be imposed. And various orders have been passed, my lord, directing the respondent to place the regulation order. Even we have filed contempt petition.
You have been getting the provisional pension.
Provisional pension only since 18, my lord.
Yes, how long will you take to sort it out? This has been going on. Writ petition itself is pending since 2021.
And there is an direction, my lord, in the provision pension cannot be granted beyond 3 years, my lord.
I didn't advise us to take, my lord.
Now that we have seen, that is of when? 26/9. But why are you so late in making these communications? Heard. Sri D. Bora, learned counsel for the petitioner, who submits that it is only provisional pension which the petitioner is getting.
My lord.
Full stop.
I am the wife, my lord.
Yes, you're the petitioner. Petitioner is getting. Full stop. Para, Sri, who has, you have given this? Sri Bora, P. Bora, learned standing counsel. Which departments? Elementary Education Department has placed before this court a recent communication dated 26/9/2024 issued by the department, as per which the matter was placed before the finance within bracket EC-Roman 3 department, and thereafter on advice has been endorsed to the ARTP & PG department for the views regarding regularization. Full stop. Para. Though it appears that some process is on, delay in finalizing will not be in the interest of justice. Para. You for?
Accountant General Miller, do we have 5 that we have not reached?
Oh. C. Borough নাম তো লিখিবে
I don't have PDP.
Be that as it may, list this matter for further consideration, list this matter on 25th of October, by which date the up-to-date instructions are to be obtained by Sri Bora.
I am also praying for interest on the.
Let's see.
pension.
Let it come first, we'll consider.
And my lord, compensation, regarding compensation, the court has raised a question, my lord. They have not filed any affidavit regarding that.
We'll look into it.
Okay.
Bless.
Item 8.
May it please the Lord. In this case, my learned friend respondent number 6 and 7 filed affidavit matter. So I pay 2 weeks time.
On the prayer of Sri M.R. Khandokar, learned counsel for the petitioner, 2 weeks' time is granted to file rejoinder affidavit to the affidavit in opposition of the respondent numbers 6 and 7. Your name?
Yes, Doctor.
S. Chakraborty. 6 and 7.
6.
I am
Present. Huh?
Item 9.
Lordship, third time being lost after some time.
After some time,
Yes, we have received the Parawes comment. Let us file our affidavit.
notice was issued only. Okay.
Yes, ma'am.
Sri P. Bora. Mr. Chaudhary, you are also appearing.
I am appearing for yes.
You'll be filing affidavit. No.
Mainly they will be
Okay.
here because they have rejected the 14th.
They have received the instruction, let them file affidavit.
My lord,
There were lost 10 cases or similar order were passed. Not all these cases were disposed of. Only this case is remained lost. I am giving the similar order, exactly same case.
Let us file our affidavit.
Okay. While Sri M. Khan, learned counsel for the petitioner, submits that there is a judgment of this court which should cover the issue,
My lord.
Sri P. Bora, learned standing counsel, Elementary Education
My lord.
Department, submits that instructions have been received based on which he would like to file an affidavit. Full stop. Also heard Sri B. Chaudhary, learned counsel for the SSA. Para. List. We'll give fix a date.
My lord.
List on 25th of October 2024, by which time the affidavit may be filed. Full stop. On the next date, the aspect as to whether the issue is covered would also be considered.
My public.
Place the judgment and show it to your friend.
My lord. Item 10.
In this matter, petitioner has obtained the master degree from the CMG University, and some litigation is also going on regarding the validity of CMG University. And some time is required, and I have not received the instructions here also.
Who is you have taken service steps by Dusty upon whom?
CMG University. Thereafter, Lordship, affidavit has been filed regarding the system. On last occasion, Lordship, 2 weeks time was given, Lordship, to them to file another.
But degrees of CMJ, are those valid?
My lord, here, Lordship, the
Okay,
petitioner.
you file your affidavit.
Yes, yes.
On the prayer of Sri U. Sharma, Learned Standing Council, Secondary Education Department, further time of 3 weeks is granted to file counter affidavit.
Hello.
But this matter is of 22, file it early.
Yes, yes.
Whether it is, you have
sir.
to make your stand very clear. Eleven years.
In this matter, we were supposed to file an affidavit, my lord. I've received my instruction, my lord. I'll be filing my affidavit, my lord. We'll fix it immediately after the vacation.
Contempt matter.
No, my lord. So read petition.
Item number?
Item number 11, man.
Okay.
Item number 11.
Okay. You're for elementary.
I'm for elementary education.
Okay. Sri A. Fukan. Learned Standing Council, Elementary
Lordship, on
Education.
page number 54, Lordship, there is a simple ground that Lordship NUFA is not given. And Lordship, we have annexed in the annexer 1. That is in page number 20. That the NUFA dice code.
Okay, let them fight the affidavit.
I'll get
Learned Standing Council, Elementary Education Department, prays for and is granted further time of 3 weeks to file the affidavit in opposition. Full stop. We fix the date 22 matter. List on.
30th,
We'll have it on 25th of October.
25th,
Okay. Friday.
Friday.
Lordship, can I pray for there are similar 3 matters that can be taken together?
Give the numbers. List along with.
Much okay.
Give it to our court master. Okay. List along with sir,
DPL.
which are stated to be similar.
In this matter, I have received one instruction of that initiative has taken and matter has been placed to the draft cabinet. My lord, department has prepared a draft cabinet memorandum which is now under the process and file number so and so for posting the matter before the cabinet. Now the file is endorsed to legislative department for necessary check. So regarding the modification or amendment method. Rule 5.
I think your grievances will be redressed. Some process is on.
Right.
Okay, heard. Sri Talukdar. This is item number
12.
You are for which department?
I'm for the secondary education department.
Okay. Heard Sri P. Talukdar, Learned Counsel for the petitioner. Full stop para. Sri U. Sharma, Learned Standing Counsel, Secondary Education Department, by placing has submitted that there are written instructions dated 26/8/2024, as per which certain process is on for amending Rule 5 within bracket 2 of the Assam Secondary Education within bracket provincialized schools bracket close service rules, 2018. Madam, you are for? Who are you?
Principal.
And no role. Also heard Ms. N.S. Thakuri, Learned Counsel for the response number 4. Para, in view of the submissions made by the Learned Standing Counsel, matter is adjourned by 4 weeks to be listed on 28th of October 28. On the next date, the up-to-date development are to be informed to this court.
My name will be recorded for item number 13, Melvin.
Connected?
Yes.
What is 12? 12 is your case. Okay. Okay. We'll have B Purkasta, huh? In Duta Likhiba. P Talukdar for so and so, B Purkasta and so and so. It's similar?
Similar.
Item 14.
matter pertains to the family pension matter. The petitioner is the first wife, there is the eldest wife of the deceased employee, but the family pension has been given to the second wife. Therefore,
Now the division bench will cover, full bench will
yes, full,
cover.
full bench decision, I am entitled, my lord.
Oh.
And also, my lord, nomination cannot prevail over the statutory provision.
Yes.
Appeal to the accountant general, we have nothing to do in this matter.
Who's for the private respondent?
Mr. M. Mahmood, my lord.
Name shown or not?
His son's name has been shown, my lord.
SH Mahmood. Name. Heard. 3 SK Roy, learned counsel for the petitioner, who submits that the matter would be covered by the judgment of the Honorable Full Bench. Full stop. Do Sri B. Sharma, learned standing counsel AG, as well as Sri U. Sharma, learned standing counsel, secondary education, are present, comma. The learned counsel for the respondent number 8 is not present when the matter is called upon. Full stop. Para, in the interest of justice, matter is adjourned to give a further opportunity. Full stop. The matter be listed on the reopening, 21st.
Date is
21st.
21st month.
Reopening date. 21st na 23rd ko 23rd
23rd.
October.
But this case, my lord, petitioner were appointed, my lord, as visit teachers, my lord, in Adarsh Vidyalaya. With following due procedure of law, my lord, they joined in their post, my lord.
BTC.
My lord, I am appealing on behalf of Asarapa. He instructed me to state before this court that draft affidavit has been scanned for 15. So he will
You file the affidavit, okay.
after
What is your name?
P. Hazari.
Sri P. Hazarika, learned counsel, appearing on instruction of Sri S. R. Rabha, standing counsel BTC, submits that the affidavit has been prepared and sent for vetting. Full stop. He accordingly prays for and is granted 3 weeks time to file the affidavit.
Any date, my lord?
List in the list on 28/28. October. 28.
16.
But in this case, matter related to scale of pay, regular scale of pay, my lord. Education department has filed affidavit, but finance
We have
department,
filed an affidavit on March 24th.
but finance department,
This is the last order.
last two orders.
Finance department's.
Yes, finance, who is appearing? Finance. Finance, madam, finance. You're with Nayak. Who is it, Nayak? Yes, finance, you're silent.
No, lord.
Mr. Nayak, on one matter, we have recorded your name for item number, RMS, Rastriam and Finance.
RMS.
First matter, motion matters.
Item number 10, lord.
Ten.
Mainly,
Yes, here you are supposed to file an affidavit.
Lord, if lord takes up this matter after some time, lord. My colleague Rajiv Bhattacharya was defeated.
hastily,
Okay, after a while.
Item 17.
Representation of people. Response filed.
Yes, lord. In this matter, lord, if I have filed one IA is not effective. For extension of time for filing the WS because of medical condition. One prescription has also been.
How soon can you file?
Dr. In this application, we have paid for 4 weeks time. In the meantime, almost 10 days has already elapsed.
I had to unlock the, I had to file for. Oh, to maintain all transparency, let the IAB brought before us on Monday. Monday,
But
there's
they
a-
have kept it on defective. Let me be, I have the instruction that it has been filed, but it has been kept on defective mode so that it is not listed. If it removes the defect by today, at least the same prayer otherwise will be made that it is not there before the court.
then we'll not consider.
My lord, in fact, that's what he has now I have forwarded one photocopy of this copy because now I found that
Heard Sri KP Pathar Learned Senior Counsel for the petition. Also heard Sri P Nayak Learned Counsel for the respond number.
One.
For the respond number 1, who submits that an IA has been filed, which, however, has not been listed. Quotes the para. This court, however, Sri Pathak, the Learned Senior Counsel, has, however, submitted that as per instructions received by him,
that has been
the petition is lying defective.
defective
Is lying defective.
since the date of file.
Effective para. Sri Nayak is directed, the Sri Nayak, the Learned Counsel, is directed to remove the defects and the IAB listed for consideration on Monday.
My
Okay.
Monday, though there's a DB in the second half, DB will not be in the first half. First half will be there, single bench.
The matter will be taken away.
Yes.
My
May I please, Lordship, this is a matter relating to non-regulation of the service of the petitioner. He's working since
We are directed to bring instruction on the annexed 6 matter. Well, we have not received. I need some time.
24 matter, okay.
Lordship since 1981 I'm working. I'm suffering.
Immediately after vacation, I'll
Okay.
try to.
On the prayer of Sri P. Bora, Learned Standing Council Elementary Education, matter is adjourned to be listed immediately after the vacations to enable him to obtain the instructions. Get the instructions, he's suffering. Get the instructions.
My lord, because as per this annexure, my lord, their service has been regularized by the commissioner.
Yes, but it's it is upon the approval of it depend upon the approval of the finance.
Okay. Yes, next.
Obliged.
Lordship, Mr. Esper is on late. I am on his behalf. He is waiting for instructions, so it may come after vacation.
It is for BTC.
Lordship, may I please, Lordship. Lordship, election first held, interview was held earlier 22, Lordship. 2 years, I was the selected candidate, topmost candidate. But BT has said he has thought time again and again. Till today, no appointment has been given, Lordship. Lordship, at least.
24 matter.
No, Lordship, earlier I have approached 22, Lordship. It is second time with petition, Lordship.
This we are not deciding 22 matter. The petition before us is of 24.
Yes. But selection was 22. Yes.
We have to see from the point of view when you have approached this court. What is the stage of this case? Yes, madam, he's in a hurry. You take the instructions.
Yes, Lordship. To and
The order dated 9/9/20.
Are you seeking time or what?
Yes.
For?
To get instructions.
Okay, we'll fix a date in that case. Okay. Heard
I am for, I don't know, 20 minutes.
20. Heard you are? AK Azad.
My lord.
Heard Sri AK Azad, Learned Counsel for this so-and-so, and Sri D. Mohanta, Learned Counsel for this so-and-so, huh? Rutas. Who expresses urgency in the matter. What's the para? Here, madam, your name?
Here,
Ms. J. Raskumari, Learned Counsel, appearing on instruction of Sri S. R. Bora, Standing Counsel BTC. S. Bora, Standing Counsel BTC.
Okay.
However, prays for time to obtain the instructions. Full stop. list on 28 to 8
My
enough time to 28 October
Publish.
to enable obtaining of instructions / filing of affidavit in opposition. Mr. Bora, 28 file your affidavit or
Interim order is there.
interim order passed earlier to continue till the next date of listing. What is the interim order?
Interim order not to appoint lordship. Suspension. Appointment.
You are also public interest being suffered. Come up with the instructions. 28 to 8. Okay. Next.
Publish.
Thank you, Your Lordship. Yes, it's relating to my lord, the selection and appointment of assistant professor, my lord, in Assam Agriculture University. Now, my lord, there is
Matter
an
is
interim
instruction,
order.
already they
Yes, my lord.
participated, matter, let the results be published, matter.
My limited prayer is, my lord, let a record be called for immediately after opening of the.
Record, they have,
And my lord, thereafter I have no case, if I am not selected, no
their
case.
prayer
then
for
I will
participation, allowing to
Only
participate, my lord. They
They
already
have
participated.
participated.
Yes.
Let them declare the results.
Their record may be called for
No, no,
because my
why?
lord, apprehension is, my lord, she is much, the petitioner is higher qualified. And the other two
Now, if
candidates,
the
there are
record,
only three
if the
candidates.
results, in the results, it is
candidates.
found that you are.
Then complication will arise,
no, no,
somebody appointed, my lord.
The prayer is also for appearing in the interview, matter.
It is there, my lord, I don't disagree that it is there, but my lord,
Case
since
25.
since she is highly qualified on one basis they are selected, your lordship may close it on the next date, my lord.
No point.
For
Heard
the
Ms.
record,
Anne Saikia, learned counsel for the petitioner. Also heard Sri P. Kotoki, learned standing counsel,
Yes.
Assam Agriculture University. Full stop. This writ petition has been filed with the following relief. Put the relief, page 25. Tara. It however transpires that pursuant to an order dated 7/8/2024 passed by this court in which the petitioner was directed to be permitted to appear in the recruitment process, comma, he was indeed she was indeed allowed to participate, full stop. Sri Kotoki, the learned standing counsel, has submitted that after such participation, comma, the relief prayed for has been exhausted and the writ petition has in fact become infructuous. Para. On the other hand, comma, Ms. Saikia,
my
the learned
submission,
counsel,
my lord, the records of the selection committee may be placed
learned
before.
counsel for the petitioner has submitted that she has apprehension
Yes, my lord.
that her higher qualification would be ignored in making the selection and inferior and a candidate inferior to her on merits would be selected. Full stop. Para. The aforesaid submission would be on the realm of speculation as the results are yet to be declared. Full stop. Para. In view of the above, comma, this court is of the view that no live cause of action remains to be adjudicated, and accordingly, the
Then
writ
we
petition is
dispose of-
closed. Full stop. The authorities are at liberty to declare the results. Full stop. It is needless to state that if the petitioner is aggrieved by the same, comma,
result.
she would be
Liberty
she
to
would have the liberty
approach this court.
for liberty to approach the appropriate forum for redressal of her grievance.
All right.
So I said 9. You get it, no? Adjournment.
Here, my lord, we have got for the instructions from the finance department. It is evident, but here what I have find, my lord, the finance have in turn, my lord, communicated with the secondary education department, seeking their views. Because here, my lord, the cabinet memorandum is put under challenge. And in that cabinet memorandum, it appears, my lord, that views of various departments were obtained, among which, my lord, the finance department has also expressed its views. So our affidavit will be required, my lord, for defending that cabinet memorandum. Possible kindly accommodate me.
No, you are given earlier time.
Yes,
It's
yes,
matter
my
of
lord, no, my
23.
lord, we have communicated, but the difficulty is that, my lord, the
Okay, we'll
notification,
grant you some time.
my lord.
On the prayer of 3 R. Borpujari Learned Standing Council, Finance Department, further time of 3 weeks is granted to file the counter affidavit. We'll fix a date.
Yes, my
List on 28, 28 তারিখ।
28th of
28
October,
Jan.
my. I'm so obliged.
Six. Finance? Yes, yes, pension matter.
Pension matter.
Mr. Deori, on the last occasion, I think we had given you time. Only two petitioners, 2 and 7. Last time, if you remember,
yes.
others have been paid.
Yes.
2 and 7, there were some communication gap.
Lordship, I sit for just 20 minutes. Sure. Let me.
Okay. You take more than 20 minutes. You come at around 2 o'clock.
Yes.
Okay. Item 23.
But then I simply sorry, I did this better today.
But
After
this is
some time,
pending since long. We'll take it up 2 o'clock.
it would have also, my lord, I was supposed to produce one judgment. I have already taken out.
2
the
o'clock.
Lordship, can it be before 1 PM? At 2, there is an RSA hearing, Lordship, part
Okay, we will try to do it before 1
Lord-
o'clock.
We will sit here, Lordship, after, before.
Item 24. Oh, very bizarre, no? Yes, you are seeking adjournment. Who is appearing?
My lord, we have filed impleadment petition in this matter. The earlier
Not listed.
respondents were transferred.
I have not been listed.
No, my
When did you file?
actually the respondents who were appeared in that they are not in their position. Now,
Your impleadment application, have you
Yes, yes,
filed?
supposed to
yes,
file.
my lord.
You have filed already?
Yes, my lord, we have filed.
When did you file?
Yes,
it?
yesterday.
Okay. It is submitted that IA for impleadment has been filed, which however is not listed. Full stop. List the IA said to have been filed on Wednesday next.
Yes.
Wednesday
Yes,
next.
Wed-
Date. Wednesday is a holiday, I think.
Oh.
Wednesday is a holiday. On Thursday next. 3rd.
Copy the device.
But since on the last order, it has been reflected that due to the read appeal, some clarifications are required. I'll pray that this matter may kindly be fixed in the first week of November, subject to your lordship's convenience.
Mr. Das?
Yes, sir.
Sri BD Kaur and Senate Council for the petitioner submits that in view of the observations made by this court on the last occasion,
On 9/9/2024.
the last occasion, which involves the connected appeal being WA 307 of 2021, comma. He seeks, time has been sought for. What's the para? as requested, list on first week of November,
My lord, the 11th of November,
list on 11th of November.
we are blessed.
Sri as the Esplanade Council for
Alright.
the, for the respondents are present, is present.
We are blessed.
Again, 26 to 25.
Yes,
There is an order to file affidavit here, sir. That affidavit,
affidavit by whom?
the elementary department.
Elementary, yes, elementary. Madam, elementary. Mr. P. Bora. Affidavit filed, not filed.
My lord, my lord, basic issue in this case, my lord, whether Hindi teachers are linguist teachers or not. My lord, all the petitioners are, my lord, Hindi teachers of upper primary schools, my lord. Their service has not been professionalized, though they are seniors, my lord. So, my lord, we have earlier occasion we filed approach this.
You're all Hindi teachers.
My lord,
And they are not treating your subject to be language teacher.
my lord.
That is your grievance.
Yes, my lord. So, my lord, on earlier proceeding, my lord, elementary edition filed an affidavit, my lord, where they have clarified the matter that the Hindi language, the Hindi is a language and it comes within the definition of section 311 of 2017 Act, my lord. And my lord, on earlier occasion, my lord, they relied on that affidavit that Hindi is a language. And that, my lord, that
So in this case, the affidavit has been filed or not?
and in this, my lord, in this present proceeding, my lord, they have not filed. They are, my lord, they are relying on the affidavit filed on earlier proceeding.
Where is Mr. Chisti? Chisti was there, I think elementary. Mr. Chisti, elementary education, none is there.
He was supposed to appear. Yes, very clear.
Some affidavit was supposed to be filed, not filed as yet.
In It needs some time. But our case is like that, your lordship.
What division bench has decided?
No, not yet decided. I think division bench is still pending. I think there is a challenge to section 3111 and the division bench matter, it has been reserved, your lordship, for final.
Okay.
Yes.
This court has been informed. No. On the last
That
occasion,
was-
that is
yes, yes.
24/7/2024, the following order was passed. Full stop, para. This court has been informed that the matter is yet to be disposed of by the Honorable Division Bench. Full stop. List after 4 weeks. Full stop. In the meantime, the Education Department may also file the affidavit. If there is any judgment prior to that, kindly mention it. We'll take it up.
Yes. Okay, yeah, true, that is. Obliged, lord.
My lord, in this case, I filed an affidavit, my lord, in respect of postal service of restaurant number 9.
You have filed affidavit?
Yes. on 9/8/2024. Acknowledgement is annexure D at page 95.
Okay. Heard. Sri A.K. Purkast, learned counsel for the petitioner, who has drawn the attention of this court to the affidavit filed on 9/8/2024 in connection with the dusty service upon the respond number 9. Peruse the same, including the enclosures thereto. Full stop. The service upon the respond number 9 is held to be complete. Full stop. List after 4 weeks for admission. Full stop. In the meantime, comma, the respond number 9 may enter appearance if so advised.
My lord, there is an interim order, my lord. Kindly
Interim order passed earlier
dated
to continue
24/7.
till the next date of listing.
My lord, obliged. Item 38 and 39.
Yes, review.
Your lordship. Here also we are taking the review of my lord order lordship. It is in page lordship 19.
Hmm. Yes, yes. 27, order 27, rule 8A.
Rule 8A.
Here the railways.
Then lordship says pass similar order. Tara.
Okay. Madam,
Lordship, I have filed an affidavit in opposition and I have categorically mentioned that this review petition is not maintainable in terms of the judgment passed by the Honorable Supreme Court in the case of PAM Developments Private Limited versus State of West Bengal. Lordship.
where is it?
I have categorically made a statement in paragraph 10 of my affidavit in opposition.
Affidavit filed where?
It is marked as flag A. Page number 23.
Okay. Just a minute. Yes, what have you stated?
Lordship, paragraph 22 is relevant.
22 page.
Page, the judgment, I have mentioned about the judgment, Lordship. The relevant
22 paragraph, not 22. In an affidavit, it will be something else. There are only 16 paragraphs in your affidavit.
22 paragraph they have quoted.
The judgment.
Or judgment,
They have
PAM.
quoted.
PAM development.
Okay.
They have also quoted in paragraph.
In paragraph 10 also.
10,
it is
10.
there.
Yes, what is the ratio?
Paragraph 22 says, Lordship, that even otherwise, a plain reading of Order 27, Rule 8A CTC would make it clear that the same is only regarding security as mentioned in Rules 5 and 6 of Order 41 CTC, which is not to be demanded from the government while considering the stay application filed by the government. It, however, does not provide that the decretal amount cannot be required to be deposited in the appeal against the money decreed. Para 23. However, in 1976, Sub-Rule 5 to Rule 5 of Order 41 CPC was inserted, which reads as follows. 5. Notwithstanding anything contained in the foregoing sub-rules where the appellant fails to make the deposit of against the security specified in sub-rule 3 of Rule 1, the court shall make an order staying the execution of the decree. Lordship, emphasis applied, Lordship. The same provides for making of deposit or furnishing security by the decree holder seeking stay. It would thus mean that after 1977, the appellate court has the power to direct for deposit of the decretal amount, which was earlier limited only to furnishing of security under sub-rule 3 of Rule 5 of Order 41 CPC. It is noteworthy that after insertion of sub-rule 5, there was no amendment to Order 27 Rule 8A CPC to exempt the state government for making such deposit, which would mean that Rule 8A does not exempt the government from making deposit, which the court has the power to now direct under Order 41 Rule 5 CPC. Now, Lordship, coming to Para 29. Although we are of the firm view that the Article Rule 8A of Order 27 CPC has no application or reference in the present time, we may only add that even if it is assumed that the provisions of Order 27 Rule 8A CPC are to be applied, the same would only exempt the government from furnishing security, whereas under Order 41 Rule 5 CPC, the court has the power to direct for full or part deposit and or to furnish security of the decretal amount. Rule 8A only provides exemption from furnishing security, which would not restrict the court from directing deposit of the awarded amount and part thereof. So, Lordship, after that, Lordship, in the similar circumstances, the railway preferred one review in MFA review petition number 178 of 2022, and the Honorable Justice Devashish Barua, by relying on the same judgment of the Honorable Apex Court, Lordship, this review petition was dismissed, Lordship. This can keep it. So, in view of the judgment passed by the Honorable Apex Court, Lordship, the review petition is not next.
Easy to deliver. Yes.
That part was I have to examine, otherwise I am relying on one of the division bench judgment of our High Court. As my friend has indicated.
Okay, okay. Third, the K. Gogoi Learned Counsel for the applicant seeking review. Full stop. Ms. M. Sharma, Learned Counsel for the opposite party, submits that objection has been filed. Full stop. She has also relied upon a judgment of the Honorable Supreme Court in the case of PAM Developments ... reported in 2019 8 SCC 112. And full stop. She has submitted that the aspect of the exemption under Order 27 Rule 80 of the CPC has to be read along with the provisions of Order 41 Rule 5. Full stop. Para 3. Gogoi is for some time to examine the said aspect.
Lordship, another submission, Lordship.
No, we are not taking it today. We are not taking it today. He's taking time. Okay. When? Tell us.
After vacation also.
List.
In first week of November or second.
List in the first week of November 2024.
The other case is also not, Lordship, maintainable because it is covered with the decision of the Supreme Court, Lordship. I will place the judgment later.
Okay,
let's contrary judgment also there, Lordship. I will place it.
Next to Khali PAM Development. List along with book.
Lordship, a date may be fixed.
Tell us.
Lordship,
4th of November.
Lordship, Lordship,
4th November.
Lordship,
You place this on the next occasion. Oh, no, this let it remain here. We have to incorporate in the order.
Lordship.
highly of.
The other case means which other case?
MFA.
MFA, we are not passing any orders. We are under review. Okay.
Oblige.
Elected na lage, etu eta yes. Along with no MFA আছে, to
Maybe
review.
the Lordship. Here in this matter, Lordship, we have taken the steps. But
Item
as
number?
copy is not dated 19 September, Lordship, neither ID card nor unserved notice has been received by Lordship.
Yes, education department, anybody? Madam, you take instructions on this informally. It's a contempt matter. We cannot direct you to appear, but neither ID card nor unserved notice. If we presume service, it will be in difficulty. It will be in difficulty. It is the secretary of the department and State Council for Education Research, the director. Okay, take instructions.
Yes.
Give her a copy informally, okay? We'll not or make any observation, but office note dated 19/9/2024 reflects that neither ID card nor unserved notice has been returned back for the respond numbers 1 and 2. Full stop. The notices were issued on 29/4/2024. Para. List for consideration on 23rd of October.
Yes, my lord.
Give her a copy. And not the case, 23rd we are fixing.
Their names may be shown, Lordship.
Then how can they, it's a contempt matter. You're only to facilitate you, we are making this observe.
Oblige, Lordship.
Well, service has been complete. My lord, only thing is that the interim order that was passed on 18/3/24 was violated by the inspector of schools because he has handed over charge to another teacher, my lord. And today I got to get a hold of an order.
You have
Whereby-
the order.
Yes,
Place it on record by an affidavit.
Yes.
We'll take action.
my lord,
Yes.
that observation may be made, my lord.
Okay, heard. Sri M. Khatonia, learned counsel for the petitioner, who submits that despite there being an interim order of 18/3/2024, that the charge of the post of the principal is to be retained by the inspector of schools, Nagaon,
No, ma'am.
until further orders, the said charge has been handed over recently. Full stop.
To the writ petitioner of 1084, my lord.
Recently, full stop. Let the aforesaid development be put on record by way of an affidavit, which may be filed within a period of 2 weeks from today.
Obliged.
Madam, you have understood.
Yes, my
You
lord.
advise
Yes.
your clients, if something has been done erroneously, ask them to rectify others. There will be complications. Okay, next.
Pin for an-
Yes.
My lord, in this case, we have filed the miscase, my lord, as because during the pendency of this case, my lord, they have issued one impugned letter or order, my lord, whereby the claim of the petitioners for promotion to the post of principal of the special higher secondary schools been mechanically rejected. They have taken the ground that the existing service order, the service rule is not permitting. And in the instant writ petition, my lord, itself, that the service order is put to challenge.
Now we have these rules, so
You have?
we have these rules, as per the rules we have.
No, what do you have to say in the IA?
We have these rules, Lordship.
As per the rules, we have rules.
No, see, in the IA, notices were issued on 28/8. Do you have something to say in the IA?
No, Lord.
My lord, this impugn may be suspended, my lord, and this is otherwise ready for disposal, my lord. Your lordship may.
Where is the question of suspension?
Your lordship may take up the matter, is ready.
In the main case, you have filed affidavit.
Yes.
Main case.
Yes, it is ready for disposal, my lord.
Okay. Right in the writ petition, huh? Though I has been filed in this writ petition, comma, this court has been informed that pleadings have been exchanged in the meantime, and the matter can be taken up for disposal at the admission stage. Full stop. Para, please for admission hearing on 30th of October, 30.
Obliged.
May I please, Lordship? Lordship, this is an interlocutory application, so we have filed for Impleadment, Lordship. And responding to that, they have filed an objections to that days before yesterday, Lordship. So Lordship may accord us some time to go through the objections, Lordship, and may hear the matter after vacation. Lord.
Maybe. Otherwise, if I may point out.
In this application for impleadment, comma, the writ petitioner has filed objection. What's the para? As requested by the learned counsel for the applicant, list for consideration immediately after the puja vacation.
Lordship. Highly obliged, Lordship.
Item 44 and 45.
But here in this case, I have filed an impleading petition to implead the new incumbent ballot as respondent number 11.
Just a minute. Hey, okay, bail to the asil. মাটি দিয়ে নহলে মেটাৰ নহলে কি কৰিব বহি থাকিম আৰু এটা আছে নহয় বেলেগ এটা কোনটো আছিলে এইটো কি আছিলে এইটো আৰু আলি ডিউৰি এতিয়া মাতি দিয়ে নহলে ক'ত মাতি বহিব দুটা বজাত এনে এইটোতো লাষ্ট মেটাৰ 46 টো নাই এইটো লাষ্ট মেটাৰ Yes, what is it?
This is an impleading.
Mr. Kaushik, we here, matters are exhausted. We'll take it up now. Call your colleague also.
Yes.
Yes.
This is an impleading petition to implead the new incumbent ballot as respondent number 6 in the contempt case number 366/2020 ballot.
You want yourself to be impleaded?
No, not myself, new incumbent.
Okay. You are the applicant. You are the
I'm the-
petitioner applicant.
Yes.
Okay. Yes. First time it has come.
Yes. My learned friend can take notice, 2020 matter. Some of the person is going to be retired, one person already died.
Contempt matter. How can we force him to accept notice?
Not forced, just requested. Earlier, my learned friend was appeared.
No, let notice go. It will not be proper.
Let notice to, I will intimate the authority of my own.
In the meantime, instruction may be taken.
For the applicant, applicants, petitioners, by which impleadment has been sought for, of the, whom impleadment of, of whom do you want to implead?
Secretary, secondary. School education. Narayan Kaur,
Of the new incumbent holding the post of Secretary, Government of Assam, Department of School Education. As respondent number
11.
Full stop. The learned counsel has also referred to the communication dated 12/8/2024 made to the said incumbent requesting for compliance of the order in question. Full stop para. After hearing, comma, the application for impleadment is allowed and the below mentioned incumbent is impleaded as respondent number 11.
Yes.
11 to say page 9, page 6. That's what in the main contempt petition you write. This court-wide order passed today, that is so and so, in I number so and so, has impleaded the following incumbent as respondent number 11, incumbent to now. Sri R. Islam learned counsel for the petitioner is accordingly required to file amended cost title within a period of a week. Full stop. Consequently, steps are to be taken for service of notice. Cost title. So issue notice to the newly impleaded respondent number 11. Let steps be taken for service of notice upon the newly impleaded respondent number 11 by registered post with AD. Steps within a week.
45 is also same, my lord, just the contempt name numbers are different. What are better?
11.
11.
And representation dated?
Same day.
Correct.
Out of the common order, right? Much.
Yes.
That item number 6, your lordship.
You are in 6? Yes.
Right. On dated 3/8/24.
Yes.
The director of pension has communicated to the inspector of school to furnish the pension proposal, submit the
3/8.
pension proposal. Yes, on 3/8/24. That's why it has been written. It appears that there is some communication gap on the last date order.
Pursuant to the order passed on the last occasion dated 16/9/2024, Sri B. Deori, Learned State Council, has obtained further instructions. Full stop. It is submitted that the Director of Pension, which date?
3/8/24.
Has issued a communication on 3/8/2024 to the
Inspector of School.
Inspector of Schools on the aspect of pension/family pension proposals. Para list on 23rd of October, on which date further developments are to be informed. Full stop. The Sri U. Sharma, Learned Counsel for the department, is also to obtain instructions which are to be placed on the next date. 23, then hearing.
The last petition was to peruse this. They have, the lordship was referring to this.
State of Meghalaya versus Silo, lordship.
Yes.
Person is behind the bar, lordship, since 22/8/2021. In 3 years, 3 witness only. On that ground only, I have filed this bail application. Earlier, your lordship rejected 2 times. Lordship, 2021.
How many witnesses examined?
Only 3, lordship, out of 5.
Out of 5?
Yes, sir. That 2, lordship, in 3 years, 3 witnesses. And moreover, lordship, the charge sheet reflects only the name of the petitioner as accused, lordship. He is the driver. The lordship article says seized from the possession of the vehicle, lordship, which vehicle he was driving. Charge sheet says nothing about the owner of the materials, where they are to be delivered, lordship, to whom it is to be delivered. It's a temporary picture.
Yes.
Lordship rejection, first rejection is 18/4/2022 and second rejection is on 12/8/2022. Thereafter, only 2 witnesses were examined. And I have seen Lordship in NDPS cases, in most of the cases after investigation, IO transferred, Lord. And thereafter, the IO never come to depose as a witness.
Who are the
Lordship.
3 witnesses who have been examined?
Last witness, 7th
On July.
Who are the 3 witnesses? এখানে
Witness number 4 is from FSL and witness number 5 is SI Manoranjan Singh.
My lord, informant and 2 Caesar witnesses.
So 1, 2, 3. Yes.
1, 2, 3.
Witness number 1 is the informant. Witness number 2, 3 are Caesar witness. 4 from FSL, 5 is SI Manoranjan.
behind bars when?
22/8/2021.
Okay.
I'm only on the length of this detention, Lordship. On last occasion, I have cited some decisions, Lordship.
Yes, please.
In these cases, NDPS persons were allowed to go on bail, Lordship. First one, Frank Fighters, I have cited. It says 2 conditions were on last occasion I have that is Supreme Court Lordship, Frank Fighters.
Yes.
In that decision, Lordship, 2 conditions were imposed upon him. And those conditions by the High Court while giving bail, Lordship, those conditions were removed by the Supreme Court. Your Lordship asked me how it is related, Lordship. So I have only trying to say that in a foreign national who was Lordship undergoing trial, Lordship, he was also allowed to go on bail by the Supreme Court. And in number 2 decision, that is Kishore Karmakar, Lordship. He was also under NDPS Act, Lordship. There only one paragraph number 5. Paragraph 5 only states about one decision of Supreme Court, Lordship. It is now well settled that the right to a speedy trial is recognized as a fundamental right guaranteed by the Constitution and is closely tied to the right to life and personal liberty as held by this court in Husainara Khatun and others versus Home Secretary and State of Bihar, Patna, 1979, 3 FCR, page 532. That was cited and this lordship was recorded in paragraph 5. In that case, lordship, the petitioner has been charged for the offense under section 20B2C of the NDPS. He was also released on bail, lord. And in part 1, I have cited Sheikh Javed Iqbal, Asfaq Ansari, lord. Para 22 and 23.
This appeal was by whom?
Lordship,
By the accused. He was, why was he aggrieved?
which one, lord?
Kishore?
Kishore Karmakar, lordship.
His bail was granted by the High Court.
Yes, lordship. The petitioner has been charged, paragraph 2, lordship. The High Court took notice of the, only he was allowed to go on bail for 2 months, lordship. The High Court took notice of the fact that the petitioner was in custody since 11 May 2022, paragraph 2, lordship, and only one witness had been examined so far. In such circumstances, the High Court, though fit to order release of the petitioner on bail, but only for a period of 2 months. In such circumstances, the petitioner is here before this court with the present special leave petition.
Yes.
So in our opinion, it is an incorrect order if the High Court was of the view that the right of the petitioner to have a speedy trial could be said to have been infringed, then the High Court should have ordered release of the petitioner on bail pending final disposal of the trial itself. There was no good reason for the High Court to limit the period of bail. On that ground, lordship, he was allowed to go on bail. And number 3, lordship, Sheikh Javed Iqbal. Paragraph 22 and 23.
and 23.
Yes, lordship. Paragraph 22, page 6. It is a treaty law that an accused is entitled to a speedy trial. This court in a catena of judgments has held that an accused or an under trial has a fundamental right to speedy trial, which is traceable to Article 21 of the Constitution of India. If the alleged offense is a serious one, it is all the more necessary for the prosecution to ensure that the trial is concluded expeditiously. When a trial gets prolonged, it is not open to the prosecution to oppose bail of the accused under trial on the ground that the charges are very serious. Bail cannot be denied only on the ground that the charges are very serious, though there is no end in sight for the trial to conclude. This bench in a recent decision dated 3/7/2024 in Javed Ghulam Nabi Sheikh versus State of Maharashtra Criminal Appeal Number 7 held that howsoever serious a crime may be, an accused has the right to speedy trial under the Constitution of India. That was also a case where fake counterfeit Indian currency notes were seized from the accused appellant. He was investigated by the National Investigating Agency under the National Investigating Agency Act 2008 and was charged under the UAP Act along with sections 489B and 489C of IPC. He was in custody as an under trial prisoner for more than 4 years. The trial court had not even framed the charges. It was in this context this court observed as under. Over a period of time, the trial courts and the high courts have forgotten a very well settled principle of law that bail is not to be withheld as a punishment. After referring to various orders, decisions, this court further observed as follows. If the state or any prosecuting agency, including the court concerned, has no wherewithal to provide or protect the fundamental right of an accused to have a speedy trial as enshrined under Article 21 of the Constitution, then the state or any other prosecuting agency should not oppose the plea for bail on the ground that the crime committed is serious. Article 21 of the Constitution applies irrespective of the nature of the crime. We may hasten to add that the petitioner is still an accused, not a convict. The overarching postulate of criminal jurisprudence that an accused is presumed to be innocent until proven guilty cannot be brushed aside lightly. Howsoever stringent the penal law may be, we are convinced that the manner in which the prosecuting agency as well as the court have proceeded, the right of the accused to have a speedy trial could be said to have been infringed, thereby violating Article 21 of the Constitution. So thereafter, discussing some other decisions. On the basis of Lordship, that decision, Supreme Court of Legal Aid Committee representing under trial prisoners versus Union of India. Paragraph 28 is the finding.
Yes.
Paragraph 28, we are in respectful agreement with the reasoning given in K.A. Najib regarding the decision in Jahur Ahmed Shah Watali. This decision, that is Jahur Ahmed Shah Watali, has to be read and understood in the context in which it was rendered and not as a precedent to deny bail to an accused under trial, suffering long incarceration with no end in sight of the criminal trial. Going back to K.A. Najib, this court thereafter proceeded to hold that Section 43D(5) of the UAP Act does not oust the ability of the Constitutional Court to grant bail on grounds of violation of Part 3 of the Constitution. Long incarceration with the unlikelihood of the trial being completed in the near future is a good ground to grant bail. This court also distinguished Section 43D(5) of the UAP Act from Section 37 of the NDPS Act. It has been held as follows. It is thus clear to us that the presence of statutory restrictions like Section 43D(5) of the UAPA per se does not oust the ability of the constitutional courts to grant bail on grounds of violation of Part 3 of the Constitution. Indeed, both the restrictions under a statute as well as the powers exercisable under constitutional jurisdiction can be well harmonized, whereas at commencement of proceedings, the courts are expected to appreciate the legislative policy against grant of bail, but the rigors of such provisions will melt down where there is no likelihood of trial being completed within a reasonable time, and the period of incarceration already undergone has exceeded a substantial part of the prescribed sentence. Such an approach would safeguard against the possibility of provisions like Section 43D(5) of the UAPA being used as the sole metric for denial of bail or for wholesale breach of constitutional right to speedy trial. Adhering to the case at hand, we are conscious of the fact that the charges leveled against the respondent are grave and a serious threat to social harmony. Had it been a case at the threshold, we would have outrightly turned down the respondent's prayers. However, keeping in mind the length of the period spent by him in custody and the unlikelihood of the trial being completed anytime soon, the High Court appears to have been left with no other option except to grant bail. An attempt has been made to strike a balance between the appellant's right to lead evidence of its choice and establish the charges beyond any doubt, and simultaneously the respondent's rights guaranteed under Part 3 of our Constitution have been well protected. Yet another reason which persuades us to enlarge the respondent on bail is that Section 43D(5) of the UAPA is comparatively less stringent than Section 37 of the NDPS Act. Unlike the NDPS Act, where the competent court needs to be satisfied that prima facie the accused is not guilty and that he is unlikely to commit another offense while on bail, there is no such precondition under UAPA. Instead, Section 43D(5) of the UAPA merely provides another possible ground for the competent court to refuse bail. In addition to the well-settled consideration like gravity of the offense, possibility of tampering with evidence, influencing the witnesses, or chance of the accused evading the trial by abscondence, etc. declining to interfere with the order of the High Court, this court in K.A. Najib Supra dismissed the appeal of the Union of India. Recently, this court dealt with a matter where the
This is
appeal.
Frank Vitas. We have read this.
Yes, Lordship. Here, may Lordship, an objection may be raised by the prosecution side that he is a resident of Bihar and he is residing in West Bengal. For that only, I have taken this decision that even foreign nationals were granted bail by the Supreme Court. So my humble prayer before your Lordship to reconsider his application, Lordship. And he may be given a chance to proceed with it. His case was, Lordship, a trial was going on with the help of legal aid.
Yes.
Here, actually, no doubt there was a debate. And my learned friend has taken the point of prolonged incarceration, basically, length of detention. Because otherwise, the goods were recovered from his vehicle. And my lawyer has already rejected the bail petition considering all those aspects. Because my conscious possession was there.
Yes.
And my lord, the thing is that so far prolonged incarceration is concerned, in respect of NDPS case, while understand has not relied on that judgment. Basically, that was the first judgment, or perhaps that was the main judgment. But it was Mohammed Muslim versus state of Delhi. My lord, Mohammed Muslim versus state of NCT of Delhi. I will provide the there, my lord, the first prolonged incarceration issue was prepping in NDPS. And then subsequently, Katana petitions, Honorable Supreme Court and our High Court also, Defective High Court also released the petition on bail, considering the prolonged length of detention. The my humble submission is that those cases, the facts are different because prolonged incarceration in a particular case will not be prolonged incarceration in a different case. Here, your lordship will see, because my judgment relied by my learned friend, where the point was, my lord, there is no possibility of finishing the trial in short period, because there are a lot of witnesses yet to be examined. Here, there are total 5 numbers of witnesses.
What do you say the cases cited? What was the difference?
My lord, there, my learned friend, whatever judgment cited, your lordship goes through, then there is no possibility of finishing the trial in a short span of time, because the number of witnesses yet to be examined are more. And here, there are total 5 numbers of witnesses. Out of 5 witnesses, 3 already examined. That means the trial is in a packet. In Mohammed Muslim case, there are 34 witnesses yet to be examined when the decision was passed. And there is another decision, Ravi Prakash, toward the main decision of the Honorable Supreme Court. There the number of witnesses yet to be examined, or the number of witnesses examined were very different, my lord, because this prolonged incarceration whole subject is subjective. Because had it been, my lord, 10 witnesses yet to be examined, 15 witnesses yet to be examined, then this prolonged incarceration point would have been come here. And had it my learned friend approached this court, because her last bail application was rejected in the year 2022, and she that accused is behind the bar since 2021. But when now they are coming before this honorable court, when the trial is in a sense almost about to over, only 2 witnesses yet to be examined. Because there is not much witnesses. We cannot say that it will take, there is no point of concluding the trial very short, because there are 2 witnesses, they can be examined, and if the lordship see, 2 witnesses were examined in the month of July. And after that, what happened, I don't know, because the city is up to case report is up to July. Sorry, madam, February and one is February, one is the one for July.
PW two is February 2023 and PW three is July 2023.
Minus so, my
July
lord,
2024.
24. One witness in 1 year. Correct.
my lord, my point is that, my lord, there is only 2 witnesses yet to be examined. So we
But
can,
why are you taking one witness for in 1 year? Don't you think that it is
yes, madam, that's
very, very slow?
otherwise it's slow, madam. It's not, no doubt about that. But my point is that, my lord, the prolonged incarceration point, because the whole prolonged incarceration point is that, my lord, the trial will not conclude within a short span of. But here, if you're going by the number of witnesses, that point will not come.
Where are the cases?
My lord, this minus since my landed pen was arguing, I was, but I will submit the code.
Please submit it.
Those cases, my lord, although
You
those,
submit that Muhammad Muslim and the other one Ravi.
Ravi Prakash.
Mohammed Muslim, I have lordship.
My lord, because these cases are actually, in these cases, this whole prolonged incarceration point was initially taken and they were granted bail. But the number of witnesses, the number of period of tension, those are also looking at.
Relying Mohammed Muslim and Rabi Prakash, that's my learned friend cited the lordship. The Delhi High Court granted bail to Rohit in one of the case Rohit, that was 2024 0 Supreme Delhi 137.
There are certain of High Court that are also there. So lordship, see the Mohammed Muslim judgment. There were 34 numbers of witnesses yet to be examined. And he was behind the bar, if I am not wrong, around for 5 years, my lord, only 8 or 9 years.
In all the citations, Supreme Court never says about any number of witnesses, how many witnesses are yet to be examined, how many witnesses are examined. Only on the ground that speedy trial is a fundamental right. On that ground, they were allowed to go on bail.
Speedy trial and there is no possibility of concluding the trial. These are the fundamental points. But here, my lord, already 3 witnesses are examined.
Okay. We'll consider.
My lord, I will also produce one judgment from our High Court.
You produce Ravi Prakash?
Yes.
But produce it right now. We are,
Right now, I will mail it.
no, before give it before in the lunch break.
Yes, yes.
Will
Right
be
now,
the order will be of today's date. We'll just
Yes, right.
pass
Yes,
orders
right.
in the chamber. We'll think over.
Yes.
Okay. Okay. pass it.
And there is no
Aziz.
chance of awaiting trial lordship. You will cooperate with the trial lordship.
And
Legal
another
aid
point, my
counsel is
learned friend
conducted.
already taken that he is from not from
Bihar.
Assam.
For that only, I have cited those judgments, one from Nepal, one from lordship, some other country.
Okay.
In another case, lordship, the case was rejected only on the ground that trial is at the fag end, lordship. And thereafter, again, I moved this court, lordship. Till then, the IO has never come to adduce his evidence, lordship, and the fine was imposed upon the IO, lordship. In that case also, lordship. This is also from the Karimganj district, lordship. I moved that BA, lordship. In that case also, I have seen that IO never comes to adduce evidence, lordship, as because his place of posting right now is at some different place, lordship. Considering all these, your lordship may kindly consider.
My lord, at this Ravi Prakash judgment, I am pointing out to show that, my lord, there were number of witnesses yet to be examined. Only one witness was accepted. So Supreme Court considered. And the Honorable High Court order, which I am going to rely, my lord, support that.
Okay, that's all.
I'm happy to apply.
Okay,